right, good afternoon, everyone. We're going to call this June 2nd Board of Adjustment to order. First, I've got a kind of a series of rules and things that I need to cover, and then we'll call for a roll call, and then we'll vote on the agenda. So first, let me go over some of the basics. So each application for a variance request, there's 4 opportunities to vote or discuss, make comment in support of a application, and then 4 in opposition. There is a 5-minute limitation for each of the speakers. When you get to 4 minutes, you'll get a reminder that you have 1 minute to conclude your comments, and they'll have a bell or a beep sound that gives you a notification. The applicant, after both the 4 in support and 4 in opposition, gets an opportunity for a 2-minute rebuttal. If we ask questions, I have the discretion of extending time because of interruptions, or we have additional information the board is, or statements that we're requesting. When you come to the podium, give us your name and address for the record so that we can have that for the record. You direct your comments to the board, and you can also, will have opportunity that we may have to get clarification from staff, but if you will, direct your comments to the board and not to staff or people, others in the audience. Once we conclude both support and opposition statements and then the rebuttal, then we'll have a deliberation session or discussion among the board members. If you have any questions regarding the board's decision, Planning Department at 251-208-5895 will be your point of contact. And I'd ask that you keep your comments pertaining to the application and not any kind of side comments or issues that are unrelated, because the time is obviously important as we have several applications. If you have any handouts, I'd ask that you give those to staff now if we haven't already received those, so that we can disseminate them among the board members. And with that, I'll ask one more favor, that you turn your electronic device to silent or off so that we don't have any disturbance during the meeting. And for the reminder for the board members to push the mic so that everyone in the audience can hear you. As you come to the podium, you may have to lower or adjust the mic based on your height. All right, with that, Chair, call roll, starting with Mr. Metcalf.
Here.
Mr. Golden. Mr. Milling. Mr. Carroll. Mr. Morris. Ms. Farrell. And then we have 2 supernumeraries, Mr. Atchison, Mr. Williams, and I'm William Guess. So we have a quorum. It takes 5 to affirm a motion either in support or opposition of a variance request. And with that, we have the quorum. As we have recusal, we'll call on the supernumeraries to vote in the absence of the normal voting member. And if we have just one recusal, then I'll alternate between the 2 supernumeraries. And with that, we'll start with a request for approval of the agenda.
So moved, Mr. Chair.
Yeah, I have a motion to approve the agenda. Do I have a second?
Second.
Have a second. All those in favor say aye.
Aye.
Aye. Anyone opposed? Agenda is approved as presented. And we will go in order today, and I'm going to make every effort to stay on the time as it relates to each of the statements. Starting with application 6664, 6423, which is a holdover. Can the applicant come to the podium? Good afternoon.
Good afternoon. My name is Patton Hahn, 1901 6th Avenue North, Birmingham, Alabama. I'm here for Crown Castle.
Okay, and we do have a email printout from the health department that they withdrew their concerns and comments.
Yes, Mr. Chairman. It took a while, but I was able to arrange a meeting between representatives of Crown and the health department, and I believe we addressed all of the health department's concerns.
Okay. Any questions of the board for the applicant's rep? Okay. Do we have anyone in the audience, either in support or opposition today? Okay, that'll conclude our public hearing on this application.
I understand we had 2 recusals on this, Mr. Chairman. Oh, and the next one, okay, and the second one, okay, thank you.
Okay. All right. So with that, Chair, entertain a motion.
So moved, Mr. Chair.
Subject to findings of fact.
Yes.
Yes. All right. Do I have a second?
Second.
Any further discussion? All those in favor say aye.
Aye.
Anyone opposed? Motion carries. Application's approved as presented. All right, let's go to application 2, which is 6667 regarding 2550 Spring Hill Avenue. And I believe we have 2 recusals from the board on this, 1 supernumerary and 1 voting member. And with that, Mr. Allen, you'll have or Mr. Williams, I'm sorry, you'll have a voting opportunity on this. So if the applicant will come to the podium, please. And this is an administrative appeal. I know we spent a little bit of time on this last time, so. And we have we did receive some information as well that was provided to the board.
Yes, Mr. Chairman. Casey Pipes, 150 Government Street for the applicant. We presented last month on our appeal of the zoning decision that failed to recognize our legal nonconforming use, our client's legal nonconforming use of a back house as a short-term rental. The letter of decision from the staff just said it was our request for nonconforming status was denied, didn't give a reason. We heard some reasons at last month's hearing expressed by Mr. Rossler as to why it was denied. We don't think those reasons are valid reasons for denial. We've given the board some additional research on the issue because it seemed that there were some questions of law that the board might be struggling with, and we're here to answer any questions you have, but I don't know that we need to go through the whole argument again unless y'all want us to.
All right, questions of the board regarding the information provided both by staff and the applicant's rep? Okay, not at this time. All right, do we have anyone else that has information in support of the application for the administrative appeal? All right, opposition? Yes, sir. We're going to recognize them shortly.
It's Zoe and John and Isaac, 3 of our 4 law clerks for the summer. They heard Mr. Pipes and Mr. Rossler were going to have a battle down here this afternoon, so they wanted to attend.
Okay, thank you. So you wanted witnesses, is what you're saying. All right, thank you. Thanks for joining us.
I told him I was too old to remember what being a law clerk was. But best of luck to them in their careers. Jim Rossler, representing the city's Planning and Zoning Department. I prepared this morning a 4-page outline that I'll just briefly go over it with you, because we believe that the Alabama Supreme Court's October 2023 decision in the Dixon versus City of Auburn case is controlling here. On the first page of that outline, in the first 2 paragraphs, I just outline in quotes, because this is not my language, this is what the Supreme Court said. In April of 2018, Dixon, who, as I said last month, happened to be a city council person in Auburn, purchased property to use as his primary residence. He continuously lived in it and then decided that he would start renting his basement as a short-term rental through Airbnb and Vrbo. The city's zoning ordinance did not expressly regulate short-term rentals at that time. It did, however, provide that in that zoning district, only single-family detached dwelling units, accessory dwelling units, parks, and cemeteries were permitted within that zoning district. He then applied to the city for non-conforming status and was denied. In the first chart there, I compare what Auburn's ordinance said and what Mobile's ordinance says, and they are, except for some words, they are practically the same. Auburn's defines single-family detached dwelling as a freestanding structure designed to house one family as a single housekeeping unit. Mobile's ordinance defines one family dwelling as a building containing only one dwelling unit used for residential purposes exclusively by one family. Auburn's ordinance defines dwelling unit as a room or group of rooms providing or intended to provide living quarters for not more than one family. Mobile's has similar language. A dwelling unit is one or more rooms connected together and constituting a separate, independent housekeeping unit for permanent residential occupancy and with facilities for sleeping and cooking. Auburn's ordinance defines family to include no more than two unrelated people. Mobile's allows up to 4 unrelated people as lodgers or boarders. That, I will tell you, is in there for compliance with the Fair Housing Act. I then, in the second chart, go through the facts. And where you see the X in the column under Auburn or Mobile, that shows you where we believe that fact applies to both. Well, it did apply to Auburn in that Supreme Court case. It also applies to Mobile. The first one, the owner began renting the property as a short-term rental before the city adopted an ordinance regulating short-term rentals. The same fact, Auburn and Mobile both adopted ordinances regulating short-term rentals after Mr. Dixon, the owner in the Auburn case, started renting that basement out. Before adoption of the ordinance, neither of the owners in Auburn or in the Mobile case we're here on now had applied for a business license or a zoning certificate. In both of the cases, the ordinance never listed short-term rentals as a permitted use. In both of the cases, the owner never requested a favorable use interpretation from the city, i.e. calling down to the city and asking for a zoning interpretation. Can I have a short-term rental on this property? This always does that to me. The last two have a little bit of difference. In the Auburn case, after the owner began using property as a short-term rental, the city adopted an ordinance that prohibited all short-term rentals within that zoning district. Mobile's is a little bit different. Mobile's ordinance, the UDC, does not prohibit short-term rentals within an R1 district. It allows them with approval under the conditional use permitting process. And finally, both cases involve the argument that, well, the owner paid lodging taxes under the Airbnb agreement and remitted those taxes, and therefore the city knew that this property was being used as a short-term rental. I believe you heard that argument last month. Court noted that, crucially, Mr. Dixon, in the Auburn case, did not dispute that short-term rentals had never been listed as a permitted use within that district. Mr. Dixon also did not contend that the short-term rental use fell within any other specifically enumerated use that was permitted. And we went over that last month. Mobile's ordinance says that, well, if you have a use that is not listed on the use chart, the chart of permitted uses, then the city will look to the nearest comparable use in making a determination of whether that use is allowed or not allowed. And as we talked last month, we submit that that use would have been a bed and breakfast. And if you look and remember what the definition of bed and breakfast is in the old zoning ordinance, it's the rental of lodging rooms on a short-term basis, with or without meals. That sounds like the same definition of a short-term rental that we now have in effect. And crucially, under the old zoning ordinance, a bed and breakfast was not permitted in an R1 district. In the Dixon case, the Supreme Court found that there was no evidence that the city intended, by not enforcing the previous zoning ordinance against Mr. Dixon, to communicate to him that he was exempt from the regulations prohibiting a short-term rental within that district. The court concluded, and I'll just read this one, the city's failure to engage in any enforcement efforts against Dixon before the enactment of the short-term rental ordinance does not provide a basis for stopping the city from asserting that Dixon's short-term rental use of the home's basement is not a pre-existing non-conforming use. The court concluded, affirming what the trial court had said, that Mr. Dixon's evidence, which is the same evidence presented here, did not show that he was entitled to a non-conforming use status. Let me briefly go to the last argument that was made.
Mr. Rossler?
I understand. The Airbnb agreement. I've given you copies of it. Ms. Kamanis, in the letter that she delivered to you, says in a footnote that she contacted the city and nobody could find the agreement. If she had called me, she would have had that agreement within about 30 seconds. And she has it now. I've given it to her. That agreement is identical to the Auburn agreement in all of its crucial terms. And in that Auburn case, the court said that that agreement did not furnish any basis for a determination that the owner, Mr. Dixon, was entitled to non-conforming use. Thank you for your attention. If you have any questions, I'll be happy to answer them.
Any questions for Ms. Rossler?
Mr. Chair, I have a question.
Yes.
So the
Put your mic closer,
the
please.
structure that's on this property is under the 2018 code. Would you consider that an accessory structure? And if not, why not?
I do not. An accessory structure or an accessory use has to be incidental to the principal use of the main structure. In this case, the main structure is a single-family residence. What they're claiming to be an accessory structure or an accessory use is a business. It's a money-making business advertised for rent. It is not incidental to the main residential use of the property. It could be incidental if grandma lived in it, or if my kid, when he comes home from college, lives in it during the summer. But this is different. This is a business use.
Mr. Rossler, as a follow-up question, relying on the definition of incidental, I guess the way I understand you're explaining it is that it would be something akin to overflow use of the primary residence. But I mean, is I guess my interpretation of incidental, not having researched it from a legal standpoint, would be different. It would be, another use, not as heavy as a primary residence, but may or may not preclude, Airbnb business operations as long as it's, being operated within I guess, the confines of a happy and healthy neighborhood and, things like that. So I guess, is there a legal definition of incidental that would be more strictly interpreted towards what you're saying versus what I'm saying? Or it just seems like there's a lot of things in here that are kind of open to interpretation as far as how one person, especially a homeowner who has zero experience in this.
I'll submit to you that a homeowner with zero experience should have taken the time to contact the zoning department before they went into this business and asked, can I do this on this specific property, which is an R1? And they probably would have been told, no, that's akin to a bed and breakfast business. And if you want to do it, you have to go to this board for a variance, or seek a rezoning of the property.
Let me follow up with a question. So the applicant, instead of the route they took, could have approached the board with an application for a variance.
I think they could have. What we contend they should have done is approach the planning commission and the city council for a conditional use permit and go through that process, which they did not. Mr. Milling, I'll agree with you that if I have a home and I put a dentist office in the back, that's definitely not incidental. But I'll submit to you that, and again, I don't have a clear, and it's not defined by the UDC what incidental is. But the city council made that decision, I'll submit to you, when they adopted the long list of required criteria for a short-term rental to obtain conditional use permitting. They made that decision. And again, a business use is not incidental to a single-family residence. Like I said last month, I could take you to short-term rentals that will accommodate over 20 people here in this city. And that is simply not incidental to any single-family use, at least as contemplated by our zoning laws. I hope I answered your question.
So I guess from that standpoint, as I'm trying to think through, the need for the conditional use permit is to put some type of parameters. So if you've got somebody who's doing it, say, on a smaller scale, two separate units, family for the weekend or something like that versus 20, then the city can put parameters about, what gets permitted or not. I mean, is that the thought process behind it?
Exactly. There's a long list of criteria that the city council, in its discretion, can or cannot apply to a particular application. And that's why I hesitated. When I said variance, I probably shouldn't have said that. It is a conditional use permitting process that goes the other route through the planning commission and then to the city council.
Okay, thanks.
Any further questions? All right.
Thank you, sir.
Thank you. I'll be liberal with your rebuttal time because we allowed Mr. Rossler a little extra time to explain.
Okay, sure. Thank you. Carrie Commandus, also here for the applicant, 150 Government Street, Mobile 36602. Respectfully, we disagree a little bit, a lot. We think Dixon is materially distinguishable. Here, our client is renting out an accessory dwelling unit. Accessory dwelling units were allowed by right under the 2018 code to be used residentially. Second of all, Mr. Dixon, in the brief prepared by the City of Auburn on summary judgment, it cites to his affidavit, his deposition testimony, he admitted that he never paid any taxes through the Airbnb platform. which is why he didn't allege specifically that he should have had an equitable estoppel argument. So we're just going to set that aside for a minute, but that's, I think, a key difference. He was renting under Rent Like a Champion and VRBO, and as a city council member, he never actually remitted lodging taxes. Back to the uses. We have a couple of nonconformities here, and I think that's a little bit that has to be unpacked. You have an accessory dwelling unit that was rented for many years long-term as 2 separate dwelling units. At some point, our client in 2018 switched to short-term rentals. That was very close to when the city entered into a tax agreement. So they started remitting taxes to the city through the Airbnb agreement. What the cases say that we think pertain is, at what point were they supposed to know to go to the city to seek permissive use for a bed and breakfast or a short-term rental that was not part of the chart of permitted uses? The fact that the city started collecting lodging taxes sort of gave our clients the indication that this was an acceptable use. Then in 2023, when the city decided to regulate the newly identified use, a short-term rental, under the city's own ordinance, any lawfully pre-existing use should be granted non-conformity status. So back to our property. You have an accessory dwelling unit under the 2018 code. Accessory dwelling units were allowed to be used for residential purposes. This property, like many other back houses throughout Midtown, have been used for years as rental property. There was nothing under the 2018 code, the code in place at the time they were renting, that said if you started renting for a short-term use, the use then became unlawful. It isn't until the city adopts short-term rental regulations in 2023 that puts the actual owners, the property owners, on notice that they have to go get a conditional use permit. Our client, under the 2023 regulations, is not eligible for a conditional use permit because one of the places you cannot have a short-term rental is in an accessory dwelling unit. So even if we apply for a conditional use permit, if you look at the actual regulations, we're immediately kicked out because we don't qualify. Do y'all have any questions? I'm sorry to go through this so quickly. I'm trying to see. The other thing I should like to point out, in Auburn, the chart of permitted uses there says no building shall be used except for the purposes permitted. That language is not in the City of Mobile zoning ordinance. So there's not a strict prohibition. It is true that if you have a use that's not listed, you're supposed to go to the city to get an interpretation as to whether or not you can use that use. What I'm trying to say is that when they started collecting lodging taxes from all of the short-term rental people, they didn't say, go to us to see if you can have a short-term rental. They said, we're going to take your money. Oh, so there's a big difference between now, 6 years later, saying it's okay, you should have come to us for permission in the first place. I'm trying to see if there's, I think that pretty much have addressed everything. Do y'all have any questions?
Okay, do we have any questions from the board? All right, so I guess I'll have one question. So normally when we have a loss of non-conforming use, there's a period of time that lapses. A structure is vacant and it reverts back to whatever the classification. Has this particular ancillary structure ever been vacant for any, like, 2-year period or whatever?
No, sir, not to our knowledge. Until 18 or 18, it was rented on a long-term basis. It's always been, or in recent, when I say always, it is a historic structure. So, I mean, I'm not going back to 1912, but in recent times, it's been a duplex.
So it's never been vacant for a couple of years for renovation or any major
No.
period of time?
No, and so since in 19, they have consistently remitted lodging taxes to the city of Mobile for the short-term rental use.
Okay, all right. Once again, any other questions of the board?
I just have one.
Yes.
So Carrie, I guess it's your position that, I'm trying to make sure I understand kind of the process that they leased it as a long-term rental and then transitioned it to a short-term rental 2018 through Airbnb contract agreement. Through that contract agreement, lodging taxes were remitted to the city of Mobile. And so as far as your client's concerned, they did not know that they were out of compliance with anything or that they would have needed to go to the city in order to get permission because they were under the impression that it was an approved use or that they were grandfathered in. Is that?
That's correct.
Okay.
And that there's nothing in the zoning ordinance in place to give anyone indication that once you transition a property from a long-term rental to a short-term rental, that you have somehow run afoul of the zoning ordinance
Prior to the UDC.
prior to the UC, correct. And you know, what's in it, and so what happens is if you don't contemplate this use as a non-conforming use, it really creates this inconsistency that it's sort of the term that's been used in other courts is that it's unworkable, that somehow the property owner has to sort of anticipate what the city is going to tell them as to what makes the use short term. Is it less than 30 days, less than 5 days? There was no discussion at all, or no language in the 2018 code to give anyone any idea of what would constitute short term. And when there's ambiguities in the zoning ordinance, those ambiguities run in favor of the property owner, not the city or the municipality.
I guess that's what I'm trying to figure out is, from the standpoint of, say a citizen, a property owner who does not know they're running afoul of, the ordinance with the city, then do they get held accountable to that after the fact? Which seems to be what the city's position is it's not the city's role to let somebody know, whether they are, doing something unlawful. But then to me, I think, well, if you don't know you're doing something unlawful or what the requirement is, how do I even know to contact the city? And I don't know. It's confusing.
Right. Well, in regulatory, when you're regulating property rights, it is kind of the city's job to let someone know that they're doing something unlawful because your property rights are pretty important. And so here, what I'm saying is our clients got the opposite message, which was that they were actually in compliance by remitting lodging taxes until the UDC was adopted in 2023. So to say now, in retrospect, that they should have come to the city and asked for permission to use their property as a bed and breakfast is, I think, frankly, a little disingenuous.
Okay, any further questions?
As
Yes.
stated last month, I asked the question, when did the city send a notice out to your client about a change being made in the law?
I'm sorry, sir?
When did the city send out a notice informing your client that a change is going to be made in the law?
So the code changed in the first quarter of 2023. Notices from the city, I believe, went out in October or November of 2024.
Well, why didn't your client respond to that notice?
That was sort of what we're doing in responding to the notice because we took a look at the current code and realized, A, we're not eligible for a conditional use permit. And then B, when you take a look at the totality of the circumstances, all the facts, it's our position that our clients are entitled to non-conforming use status. And so rather than apply for a variance or conditional use permit, we took this approach. Sir?
Any further questions?
No.
Okay.
There was a notice sent in
Yeah, I'm sorry, I have a copy of it here. I think here it is. It went out to all of the short-term rentals, the anonymous short-term rentals.
So the city sent a notice saying your short-term rental is no longer valid.
On October 10th, it sent out a letter to, and I'm not sure exactly who it went, but it came to our client, and it said that we've implemented a licensing process for short-term rentals. Please apply for your license, but be aware there may be additional zoning requirements by Build Mobile before you can obtain your license.
Okay. So, and I guess, and maybe this is for staff or counselor, that list, those notices went out to who, and how did we know the list? I mean, how did the city, where did the city get their address from to send them a notice?
I'll answer, but I'll let Mr. Guthrie fill in
Okay.
any information.
You have to come to the podium. If you'll have a second, please.
Believe it or not, there's a couple of companies. Don't ask me how they do it. But they can give you a list for a price, big price, of every short-term rental operating within your jurisdiction. And give you the name of the owner, give you the name of the address. Somehow they give you the name of or the date that it was last rented. And the revenue department, which is charged with issuing business licenses, contracted with that service to get that information. It generated a very lengthy list. Stephen, how many were on there? A lot? More? I was going to say more than 400. Definitely more than 300. And they generated that list and they sent out the letters advising people that you have to come down and get a business license. So that's what started all this process. And Carrie's right. That's what started the process, and which also generated then some issues about, are you zoned to have it? Because they can't give a business license if you're not properly zoned.
Okay, thank you. Any further questions?
Thank y'all.
All right, thank you. Question for staff. Back to my question for her. Non-conforming use. At what point does an applicant lose non-conforming use?
If it hasn't been in use for 2 years,
So it's 2 years. So did we ever at any point consider this location to lose non-conforming use for
Not
their rental?
not of our records.
Okay, thank you.
There's also in the law a requirement that in addition to the 2 years, there's got to be some evidence of abandoning that use.
Say that again, I'm sorry.
Is in addition to the 2-year requirement, there's also a requirement in the law that there be some evidence of the intention to abandon that use.
Okay, thank you.
But real quick, as a point of clarification, I mean, isn't that a totally different kind of standard? I mean, a non-conforming use with an abandoned use for 2 years really doesn't, in the same non-conforming use that they're talking about. This is
Exactly.
a previously used property
Correct.
that then
Yeah.
is,
Exactly.
when the law changes, they're saying, well, because we did it prior to the new law we have. So,
Correct.
okay. I'm sorry, I have one other question.
Well, Jeremy, I'm still not getting your point. So they had rental property. They went from renting it year at a time to maybe a week or weeks at a time. It's still rental property, right? So what would lose the non-conforming use as per your statement?
I think that what I was trying to make a distinction of in my mind was that what you were asking about with regards to losing non-conforming use because it's changing the use of the property, that's not, what they're talking about is a non-conforming use status because the law changed.
Right.
not that it had anything to do with a lack of it being used for that for a certain time
Okay.
period. That's the only kind of difference I was making. And I was just going to ask my last question to Mr. Rossler, as far as what I was asking Ms. Kamanis about with regards to kind of the burden, whose burden it is to know whether they're in compliance or not in compliance. And her response was that burden's on the city. Do you have a different opinion or kind of thought process on that, or would you concur? Or I'd be curious to get your thoughts.
I think the burden is on the owner. The old zoning ordinance puts that burden on the owner, that if you have a use, well, if you want to use your property for a specific purpose, you went to the zoning ordinance, now you go to the chart of permitted uses in the UDC, and you go down that list. Oh, I can have this dentist office in a B1, B2, B3. I can't have it in an R1. Had they done that, and I think that's the burden. If you have a use, you go to that use chart. If it's not listed, you look at that paragraph right above the use chart and says that if you have a use that is not permitted, then you come to staff, and staff will determine what is the most analogous use that is in the chart and apply that. And in this case, as we've said, the most analogous use prior to the UDC would have been a bed and breakfast. And I also point out that the old zoning ordinance allowed accessory uses, not accessory dwelling units.
Thank you.
Ms. Kamanis, if I mispronounce your name, I apologize. I have a follow-up question for you.
Sir.
So this property was previously a long-term rental. You said 2 units.
That's correct.
Did they, and there may be a staff question, did they have a business license or anything to rent?
No, because under the code, the business licensing code in Mobile, until recently, you did not have to have a business license to rent real property until you rented more than 10 units.
Okay.
And I think that code changed in 2020, maybe. But anyway, our clients never had more than 10 units.
Okay. All right. Thank you.
And so, as far as an accessory use, I don't believe there's any distinction between an accessory structure and an accessory dwelling unit under the 2018 code.
I think we've got to stop with the
Yes, sir.
comments.
Okay.
Otherwise, I got to get Ms. Rossler back up here again for another 2 or 3 minutes. All right. Any questions, comments of the board? I think that'll conclude our public hearing regarding this administrative appeal. Obviously, a very complicated issue for this board. We don't rarely get very many administrative appeals, so we have a lot of new members that have to experience this with us. Mr. Metcalf, anything as vice chair? All right. Well, once again, that'll conclude our public hearing regarding the appeal. Chair, entertain a motion.
Mr. Chairman,
Yes, sir.
as no one made a motion, I'd just like to say that this is a complicated matter and a legal one with consequences. And both sides make valid and compelling arguments as far as I'm concerned, but I'm not a lawyer. I can't speak for the rest of the board, but I know myself that I'm not qualified to render a ruling or a judgment in this matter. Again, both sides, you can hear both sides and say, oh, I agree with that, and I agree with that. But I'm not qualified. If the board were to deny the appeal, then the applicant would have the right to appeal to circuit court. And if they did that, then a judge with astute legal mind would actually make that determination. So with that being said, move to deny.
Okay, I have a motion to deny. Do I have a second?
Second.
I have a second. Any further discussion? All those in favor of the motion, say aye.
Time out, we just make sure we got the right language. We're reversing or affirming the staff's decision.
Affirm.
You said deny the appeal, but we're affirming the decision.
Right,
Okay.
correct.
That was the language in the
Gotcha, thank you.
report. Thank you.
Okay. Any further questions? All right, we had a motion to deny the appeal, administrative appeal, to affirm the staff's decision. And I have a second. All those in favor of the motion, once again?
Aye.
Aye.
Anyone in opposition? I have one in opposition. Say motion carries. All right. Any questions of the staff regarding the vote? Okay. All right. Thank you. All right. We'll move on with the agenda. Thank you. This is regarding 6529, 6394, 133 Eaton Square. If the applicant will come to the podium, please.
I promise I'm not coming
Pull,
back.
pull the mic down for you a little bit.
I promise I'm not coming back again to ask for the 10,000 variance on my side yard. I think my husband's just going to have to agree with my plans. So I'm hoping that the variance we got the last time, now I have a neighborhood. I'm actually a neighborhood. Just will be okayed for, I guess, another 6 months. And I'll try to build it.
All right, so you're asking for an extension of a previous approved application, variance application?
Yes.
Okay, any questions of the board for the applicant? And she promises that she won't be back.
I'm going to invite all of you to come see it.
Yeah. To the best of your ability, I understand. All right. Do we have any public comment regarding this? Okay. And
No, sir.
any questions of the staff, or excuse me, of the board for the applicant? All right, do we have anyone in the audience either in support or opposition? Okay, thank you. All right, that'll conclude our public hearing regarding the request for extension. Chair, entertain a motion.
Make a motion to approve the extension request, Mr. Chair.
Okay, I have a motion to approve. Do I have a second?
Second.
Have a second. Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed? Motion carries. All right, application 6670 regarding 2498 Government Boulevard.
Good afternoon.
Your name and address, please.
Jerry Strode, 310 South Ann Street, 36604.
Okay, if you'll give us your reason for the application.
Sure. We're requesting a use variance to allow us to operate a thrift store in the space adjacent to our offices on 2496 Government Boulevard. That's our office. The store would be open to the public and offer reused goods at a discounted rate. The next to us has been used as a Radio Shack for over 20 years. It's licensed B1. And so to allow for retail sales that we would have in a thrift store, we need it to be, we would need a B2 zoning, which it does not have. And so we're requesting a variance for that. We are a nonprofit that helps legally resettled refugees be here. And so in order, we would have our existing staff also staff the thrift store. And so in order for us to operate a retail space next to our offices, we would need a use variance.
Okay. Any questions of the board for the applicant?
What's the square footage of the proposed retail space?
2,500.
Thanks.
So when this was Radio Shack, it was being used as retail space, non-conforming use?
Let's defer
I
that
think
question
this
to
is where
staff.
guarantee title, the title guarantee was, I think, at one time.
Were they not next door in the space where
That's
they are?
right, they were, yeah.
And
Okay, have we addressed the question?
yeah, so it's been used as retail before, and we were just talking about non-conforming uses. It's been empty though, vacant for over 2 years?
It was before. We leased it, I think about a year ago right now, to use for our regular operations, like English classes, things like that. But with the change of administration, some of those programs lost funding, and so we're not able to, we've moved some online, and then we're not able to operate the other ones. And so we were looking for ways to kind of find other lost revenue. And so the thrift store, at the time, we thought it was, zoned for retail, but the thrift store became an idea, and so that's why we're applying for a variance.
Okay, thank you.
Okay.
And just to provide a little bit more information on that, while there was a Radio Shack in that suite for several years, it's been vacant for several years as well. Apparently, there was some sort of spa or salon that was there that did not operate legally. There was no business license or approval for them to operate. So there has been no intent to maintain that revenue, retail sales in this suite for longer than 2 years.
What's in the adjacent complex? Is that another business to the east?
I believe it's a real estate office, if I'm not mistaken, that's in there.
To the east,
That's also
On a
in that
different property.
I think that it's a church, the building to the east. The office to the east is an insurance. The office that shares the building with us to the east of us is an insurance company.
So I'm looking further to the east. It says vacant on our legend.
Yeah, I think that's a church.
Okay. All right. Any other questions, once again, of the board for the applicant? All right. Do we have anyone here either in support that has additional information to add or in opposition? Okay. That'll conclude our public hearing regarding the application. Comments of the board?
Mr. Chair,
Yes.
I'll, I concur with the staff's comments in the last paragraph in our report prior to the variance considerations of it having a long history as a retail space without really any perceivable negative impact. There are, I think, a good bit of commercial uses adjacent. So based on that and subject to finding of fact, I would recommend approval to the request.
Yeah, I have a motion to approve, subject to finding of fact. Do I have a second?
Second.
Have a second. Any further discussion? All those in favor say aye.
Aye.
Anyone opposed? Motion carries. All right, application 6671, 6566 regarding 685 Schillinger Road South. If the applicant will come to the podium. Good afternoon.
Good afternoon. My name is John Rebrick. I'm representing my client, at Walmart at 685 Schillinger Road South.
Pull the other mic down. The
Oh.
other mic. There you
The
go.
one with the light, I should have figured that out. I'm sorry. You want me to repeat that?
Yeah, please.
Because I couldn't talk really well. My name's John Rebry. I'm with Hedrick Sign, and I'm representing my client Walmart at 685 Schillinger Road South for a sign variance.
Okay. We've had a lot of the Walmart properties over the last, apparently there's a big incentive promotion to change all the signage.
Brand change.
Brand
Yes, sir.
change.
Yes, Mr. Chairman.
I think the last couple meetings, we've had a request primarily with the pickup, the signage associated with that, pickup sign.
Yes, sir. In this case, though, we're actually applying for some of the other signage on the building that are above the square footage allowed for informational signs. The 20 square foot limitation is what we're here for today because it's just a little too small to be read from the back of the parking lot.
All right. Questions of the board for the applicant? All right. Do we have anyone that has submitted anything public-wise?
No comments, sir.
Okay. Is there anyone in the audience either in support or opposition today? All right. That'll conclude our public hearing regarding the application.
Thank you, sir.
Comments of the board? Okay, we have none. Chair, entertain a motion. For clarification, the previous applications we've had at the other locations, the pickup sign is the only one I cannot remember if we approved. Seems like in the last meeting or previous meeting we had.
I think on the ones that you're thinking of, that those signs were on the side of the building. What is proposed in this application is the exact same as what the board approved in February of last year. That approval just expired. So they're just trying to get the same approval for the same signs as they had last year.
Okay. And I think the other one had a fuel station and there was some issues associated with that.
Correct. Yes, sir.
Okay. All right. Thank you. Chair, entertain a motion once again.
Mr. Chair, I'll make a motion to approve, subject to findings of fact.
All right. Thank you. Do I have a second?
Second.
Yeah, I have a second. Any further discussion? All those in favor of the motion say aye.
Aye.
Aye. Okay, motion carries. All right, thank you. We're moving on. Application 66, 6176, 6164, 5635, 5404, 1858 regarding 2540 Old Shell Road.
Mr. Chairman, I need
Yes.
to recuse.
All right, Mr. Metcalf is going to recuse himself on this application. And I believe Mr. Williams, you voted in our previous, so Mr. Atchison, if you'll vote in Mr. Metcalf's absence. All right, if you'll give us your name and address, sir.
Good afternoon. My name's Andy Scott. I'm with New Hand Signs, and my address is 161 Glenwood Street. This application is basically for, it's really essentially a mural. If it said "Welcome to Midtown," it would have been approved and be a mural. But for Keesler Federal, they're paying for this, and they would like their name on it. So it'd say Keesler Federal welcomes you to Midtown. It's basically a community mural, and with it being Keesler Federal on there, it turns it into a sign. So trying to see if we could get this approved for that. They have 2 signs up, and I think the location allows for 2 signs. So this would be their third sign.
Okay. All right, so allow 3 signs And then,
So that would be on the wall facing Taco Mama.
Yes, it's a little bit different from all the other buildings because this is it's an alley basically, so it's a little bit different. It does face Taco Mama.
so is it an actual alley or is that part of the access provided by Publix?
It doesn't go to Publix. It is an alley. People park at Taco Mama and then they can drive through and park behind the building. There's additional parking. So there is a lot of cars that drive through to get to that additional parking in the back.
All right. Questions of the board?
I have a question for staff. So applicant mentioned if it didn't have the company's name on it, it would be considered just a mural and wouldn't need approval from this board? It wouldn't count as signage, is that correct?
That is correct.
They would just be able to paint a mural by right and wouldn't need any approval?
If it does not include a brand name or product or services, then it would be considered a mural, which is not signage by definition. So, but because they want to have the name of the credit union on there, it does classify it as a sign.
Thank you.
Mr. Chair, I have a question for staff.
Yes.
So, and not to complicate the matter, but in the rendering here, we have Old Dutch and we have Dewdrop. And, you know, I don't believe we're trying to advertise those. They're landmarks, right? But technically, maybe.
What's the question?
Well, I mean, so we're, you know, the mural itself includes some brand names.
You are correct. Technically, that could be considered as off-premise signage or advertising.
So we can include that in our approval, should we vote such?
Well, it was not advertised to allow off-premise signage, so.
My client would be fine with changing those. They're just like, let's put some, you know, things you think of when you think of Midtown, and those are some things that came to mind. So we could change it to scenery of Midtown if need be. They didn't ask for that. That's just what was put into there.
All right.
So
So you can draw Old Dutch without saying Old Dutch.
we could do that.
All right, any further questions for staff or for the applicant? All right, did we have any public comment regarding this application?
No, sir.
Okay. Do we have anyone in the audience, either in support or opposition today? I know in the past, thank you. That'll conclude our public hearing. I know in the past, we've had some of these murals, Greer's, downtown on Government Street, and I think there's a few others that have since been applied to some of the buildings. I think in the past, primarily as stated, it was as long as they didn't indicate products or the name of the actual business, it was permitted. Otherwise, I think we actually gave a variance for the Greer's, if I remember right. So anyway, with that, Chair, entertain a motion or additional comments, questions?
I think overall the mural adds vibrancy to the area and is more signage for the area than the company. So having said that, I'll move to approve, considering findings of fact A, B, and C.
Yeah, I have a motion to approve, subject to findings of fact. Do I have a second?
Let me get a clarifying question on that. Do you want them to have a condition to change the graphics so that it does not include the off-premise advertising?
Yes, removing the off-premise names of the two businesses, Dewdrop Inn and Old Dutch. Assuming those two companies don't want to ask for approval for the off-premise signage, which they may.
Okay, good point. All right, with a modified motion, do I have a second?
Second.
Have a second? Any further discussion? All those in favor of the motion, say aye.
Aye.
Aye. Anyone opposed?
I'm opposed.
Okay, motion carries. All right, and let's see, we have application 7, which is 6673 regarding 2308 Ashland Place Avenue. Good afternoon. Your name and address, please.
Afternoon, Robert McCowan, architect representing clients Will Price and Curry Stoll. It's 2308 Ashland Place Avenue. Asking for 2 setback variances, one off of Levert, asking for a 25-foot setback, and then a 5-foot setback exists on the alleyway, so asking for a 0-foot setback there.
All right. Questions of the board? All right. I was going to ask, could not the accessory structure be positioned to where it's out of that setback? I understand on the other why it's.
Which setback is that referring to?
For the accessory structure, why it could not be moved further to the, I guess, west?
It can. The changing the other setback on Levert from 25 to 40 foot would, put that into contention.
Well, the Levert, I'm in agreement. I mean, I don't see.
Right. Okay, so if that's subject to approval, then that helps us a lot with designing the accessory structure. The client would like to have that as an attached structure. And so we do have a proposed walkway that connects the two that can be reduced. But looking at the fabric of the neighborhood, looking at this particular alley and about 6 other properties that are interior lots with alleyways, there are several examples that are 0 to 3 feet off of the alley. There have been variances requested and approved for walls on the alleyway as well. So just trying to get as much leeway as possible to get more flexibility with the design and also.
Is the alley operational? I mean, it appears there's structures in the alley as you're indicating. So could that be something that potentially that group apply for maybe vacating the alley?
That's a driveway to a house just north of that. It's a 1-lane driveway that services maybe 2 houses, 3
There are a
houses.
couple, yeah, and then people do access garages from the alley as well, so.
Okay. It just, at least based on the rendering, it appears that structures obstruct the majority of the alleyway.
Yeah, other neighbors do access this alleyway.
Okay, well then that point's unnecessary. All right.
Mr. Chair, question. Robert,
Yes.
In a historic district, you can go 150 feet in any direction and use their setback. Does that not apply here?
That is true, and that's one of our arguments for the other setback in question, but for this one, there are structures well within that are, I think, more than 3 within 150 feet that do have 0 to 3 foot setbacks on the alleyway.
So, and maybe this is a question for staff, is a 0-foot setback not allowed by right since it's?
So the UDC in historic district overlays does have a specific section that addresses corner lots and requires the property that you're using to establish the foundation for your setbacks to be at that same corner. So really there's only one other property that's to the south of this site that can be used for that condition.
That helps. Thank you. Because I did this same with the garage in a historic district, and
And that's before 22, though.
Yeah, exactly.
Okay, any further questions, comments? All right, anyone in the audience either in support or opposition? You got to come to the podium. If you'll. Your name and address, sir.
Will Price Doll. I'm that guy. 201 Levert Avenue. I'm across the street from this, like to the left of the yellow box is where I live. To her point, Marie, the 150-foot corner lot, the house to the bottom of the yellow box, the Pittmans live there. They do have an accessory structure to the south of their house. They are at 0-foot setback on the alley that runs down perpendicular to Levert, if that helps. I don't know if it does.
Okay. All right. Thank you. All right. Once again, any other comments, questions of the board? All right. Thank you, sir. That'll conclude our public hearing regarding the application.
Thank you all.
Yes. All right. Chair, entertain a motion.
I'll make a motion to approve, subject to findings of fact.
Okay, a motion
both.
to approve, subject to findings of fact. Do I have a second?
Second.
Have a second? Any further discussion? All those in favor say aye.
Aye.
Anyone opposed? Okay, motion carries. Under other business, we have 6594, 6510. Okay, Marie, what is that an application or just?
So this was a site that the board approved facade materials and other variances for in July of last year. One of the conditions on the approval letter was completion of phase 2 and the obtaining of final certificates of occupancy within 12 months, and the phase 2 facade to be built in accordance with the black and white drawings submitted with the application. So the applicant has recently submitted for building permits to complete the facade build out. And upon the permit review, staff noticed that there were some very minor changes. That being said, while they are minor, because the board approved it specifically with that condition that it was to those plans that the board approved, staff is bringing it back to you to get your approval of these minor changes to the site plans. We've got these images on your iPad as well. If you look at details 1 and 2, those are items that the board approved at their meeting last year. On the approved sites, you'll notice at the top there's these kind of tower items here that extend up. I believe that those were to cover ventilation coming up from the individual restaurant pods here. And with changes that have been made, they are no longer proposing those stacks there. There were also some string lights as well, but that, again, very minor changes. But because of that condition of approval by the board, we need your official approval for these changes to the site plan.
Okay. Any questions of the board regarding the modification? I know we spent a lot of time on this.
I have a question for staff. When we made that approval regarding them achieving the COs for the changes, was that under a certain timeline?
Well, again, they have until July of this year to get their final certificate of occupancy. So they have a month, and they have been made aware that if they are not able to achieve that deadline, that they need to submit an extension application to come back before the board to consider that.
And they're still not permitted because permitting department's waiting on this approval to even continue with the permit?
That is correct.
Thank you.
A question about the removal of the stacks. So the stacks were a screening of mechanical equipment, is that right?
That's my understanding. With the changes that are being made, those are no longer needing to be screened. So it's not that they won't be visible anymore.
Okay, that was my question.
Yeah, they still won't be visible, but those screening
Stacks are coming down, but that drawing is accurate in the new one in that we won't have AC units put on top of that will be visible.
That is correct,
Okay.
yes, sir.
Thanks.
Well, Mr. Milling, let me also point out that, originally this was supposed to be a 2-story in that you could go up to the second story and eat kind of al fresco up there. So they needed to protect the people who would be eating up there from the ventilation
of the individual restaurant pods. So that was the other reason for the stacks to exist. Now that a second level is no longer proposed, the need to have that safety protection is not required.
So the railing is now decorative completely. It's just the railing for a roof to make it look like there's a upstairs.
I believe that's correct.
And if they went forward with the work after they got the permit and it goes past the deadline we've given them, and let's say the board didn't offer the extension, what kind of situation would they be in at that point?
That would probably go to court, so I would defer to our legal team for that.
I'm not saying that, well, I'm just saying I would go after the extension.
I wasn't paying any attention. I don't know what the question was. I'm sorry.
I would go after I said if they start this work and they don't finish it as we requested by the year, the end of July or so.
They lose all their permits, cease and desist order and everything else.
It would be probably smart for them to go ahead and apply for the extension, I would imagine, before they spent the money.
Yes, sir. And also, when this site was at the board in July of last year, they did get a sign variance that has also expired since this time. So they do need to come back for that as well.
So a follow-up question, have they completed any of the work that was permitted or approved last time?
No, sir, they have not. They only recently applied for those building permits to complete the work. So that's why it's before you today. Like I said, staff was noticed to this about 2 weeks ago when they submitted for their permit applications.
Okay. All right. So we need to call for a vote to approve the changes as presented?
Yes, sir, please.
Okay. All right. Chair, entertain a motion to approve or to deny the changes as presented.
Mr. Chair, I would move to approve the changes that have been submitted.
Okay, do I have a second?
Second.
Have a second? Any further discussion? All those in favor say aye.
Aye.
Aye. All right, motion carries. All right, what else we have for business today? We have schedule and we have minutes. So minutes were sent to all of us to review and approve. Do we have any corrections? Okay, with none, Chair entertain a motion to approve the minutes.
Motion to approve.
Have a motion to approve. Do I have a second?
Second.
Second. All those in favor say aye.
Aye.
Anyone opposed? Okay, motion carries. And what about the schedule? Do we have to approve that today?
Yes, sir. And also for the schedule, I will point out the July meeting is currently scheduled for July 6th. So that's on the Monday after the 4th of July, which is that Saturday before. So if y'all feel that there may be a quorum issue, then we may need to consider pushing that back to the week after.
Are we talking about next month?
No, sir, next year
Next
for the
year.
calendar.
Okay. All right. Well, I think that's a good point. I think that date probably should be pushed back just for a matter of obtaining a quorum. I'll make a motion to modify the schedule for the meeting to the following Monday. Do I have a second? I have a second. Any further discussion? All those in favor of the agenda with that change, say aye.
Aye.
Anyone opposed? Okay, it's accepted. Any other business?
I have a question. I think Marie or Doug about the car lot. It was just down from the radio.
From the
shack.
Whataburger and the retail spot, yeah. We are filing a lawsuit this week for injunctive relief, asking a cease and desist order be entered until that owner comes into compliance.
Thank you.
Okay. What, any other legal activity, Mr. Anderson?
Nothing new since last month.
Okay, and I will not be here next month. Mr. Metcalf will chair in my absence. So have fun.